The Fourth Amendment to U.S. Constitution requires law enforcement to have a warrant supported by affidavit establishing probable cause before they can search your home. We all know that. But what about this scenario? What if law enforcement pulls over an individual and in their vehicle they find narcotics? Now the question becomes, does the status of being a drug user or drug distributor standing alone establish probable cause to search that individual's home? Now, at first, you might say, well, there is no nexus between the crime, having narcotics in the car, and the place to be searched, that is this person's home. And after all, when we have a warrant, that warrant has to particularly describe to places to be searched and the items to be seized. So you might ask a question, how is it that if the individual has drugs in the car, probable cause that he will have more drugs in his home? So today we're going to answer this question. We're going to look at a district court case here from the Ninth Circuit that will answer whether status alone, meaning that the individual is an alleged drug user or drug distributor standing alone, suffices to establish probable cause and get that warrant. And before we go on, I want to thank you for watching me here on YouTube. Welcome to LAWSTACHE channel. Hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of my merch, including the Do Not Arrest This Person t-shirts, hats, and these other t-shirts that I have on me today that have the Padre here from San Diego.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing United States versus Garcia, a case from the Northern District of California, so you know the court will apply the precedent from the Ninth Circuit. You also know from the introduction that this case deals with a warrant and law enforcement searching somebody's home. So let me give you some factual background so you understand this case a little bit better. Officers wrote an affidavit, so all the facts that I'm about to tell you were in the affidavit, and this is what the judge knew before issuing the warrant. The detective explained that they were patrolling an area frequented by gang members. They drove up and they saw a Buick that was blocking the right lane, the number 1 lane in traffic, and it was blocking a driveway. This vehicle was essentially double parked. When the officers got out of their vehicle, they saw a number of individuals that they had contact on previous occasions. They knew that these people were members of a local gang, or at least allegedly these were members of a gang. When the officers approached, they asked who was the owner of the vehicle, and they found that Mr. Garcia stepped up and said that this was his vehicle. Now, at some point, one of the officers illuminated his flashlight into the vehicle and saw a small baggie of narcotics. He asked Mr. Garcia about the little package. Mr. Garcia said, well, come on, man, this is for personal use. This is just a little bit of cocaine. And in fact, this was a little bit. When the officers took the baggie, which they could, because this, of course, was in their plain view, and under the plain view doctrine, officers do not need a warrant when they're looking into an area from a lawful vantage point. So here, an officer looking into the car is completely legal. When they took out the baggie, there was 0.42 grams of cocaine, so less than half a gram. Now, with this information, the officer wrote the affidavit and told the judge that he believed he had probable cause to believe that more narcotics and drug paraphernalia will be found in Mr. Garcia's home. A magistrate issued a warrant, and the officers went to execute the warrant at Mr. Garcia's home. There, they found some firearms, marijuana, and drug paraphernalia. Mr. Garcia was then charged in federal court with being felon in possession of a firearm, only one count, in violation of 922G. But he filed a suppression motion, suppressing all the evidence, the firearms, the drugs, everything that was found in the house, in the car, and so on. He said that the warrant should have never been issued. It was defective because there was no probable cause to search his home. And the question becomes, does the status alone of being a drug user or drug distributor, standing alone, provides probable cause to search Mr. Garcia's home? Now, you know that the Fourth Amendment protects you against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct that search. Now, here, of course, they had a warrant. The question is whether there was probable cause to support that warrant. A search warrant, to be valid, must be supported by an affidavit establishing probable cause. Probable cause means a fair probability that contraband or evidence is located in a particular place. Whether there is a fair probability depends upon the totality of circumstances, including reasonable inferences, and is a common sense practical question. Neither certainty nor a preponderance of the evidence is required. In determining whether a search warrant was based upon probable cause, the district court is limited to the information and circumstances contained within the four corners of the underlying affidavit. Mr. Garcia argues that the search warrant was facially invalid because he says that evidence that somebody uses drugs does not yield to probable cause that more drugs will be found at his home. Now, if you've noticed throughout this video, I've been using the terms of drug user and drug dealer and drug distributor sort of interchangeably. I was doing that on purpose because there is a distinction between these terms, and this case demonstrates that distinction. The Ninth Circuit has repeatedly affirmed searches of homes of suspected drug dealers even where there is no direct evidence linking the homes to illegal activity, because the presence of evidence in a drug dealer's home is a reasonable inference to draw. The government argues that this case law can and should be extended to drug users, especially since Inspector Lau stated in his affidavit that it is common for drug users to have additional drugs and paraphernalia at their residences. But the district court disagrees and says that the government is trying to create a bright line rule that anytime there's evidence of drug usage or drug dealing, there's always probable cause to search that person's home. But drug usage and drug dealing are two categorically distinct crimes. While the Ninth Circuit says that if is somebody suspected of drug dealing, there is probable cause that more drugs will be found at that person's home. If the individual is arrested with personal use amount of narcotics, there is no probable cause that more narcotics will be found at that person's home. After all, if we have such a small amount, there's a chance that this is all that this person has. Again, this is personal use amount. And now we know that because Mr. Garcia had only 0.42 grams of cocaine, or personal use amount, there was no probable cause to search his home, and all the evidence found inside the house must be suppressed as fruits of the poisonous tree, which means the firearm must be suppressed. And because he's charged with being a felon in possession, that charge should be dismissed. Now, Mr. Garcia also argues that the drugs found in the car, that half a gram, must also be suppressed. But the district court says that is now how fruits of the poisonous tree doctrine works, or the suppression doctrine. The district court says that the evidence found in the car happened before the warrant. And so when we're suppressing, we're only suppressing evidence that is found in violation of the Fourth Amendment. And like I said earlier, the officers were allowed to look into the vehicle under the plain view doctrine, and so that drugs that were found in the car will stay and can be used against Mr. Garcia. But here in this case, in the federal court, he was not charged with simple drug possession. He was charged with being a felon in possession. So this case should be dismissed. If you enjoyed this video, if you learned something about the distinction between drug usage versus drug dealing and how it affects a warrant, whether there's probable cause, and by the way, this rule only applies to the Ninth Circuit. I know, for example, that the Sixth Circuit says that even drug dealing would not establish probable cause to search somebody's home. So if you live in different states, you need to look at the rules and laws of different districts. So read the case law. That's how we get educated and learn more about all of these laws, the Fourth Amendment. If you enjoyed this video, give it a thumbs up. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and some other items. Thanks for watching. See you next Wednesday.